Good afternoon, everybody. I'm Kate O'Regan, the Director of the Bonavero Institute of Human Rights at the University of Oxford, and welcome to this week's edition of the Bonavero Discussion Group. I'm really delighted to welcome back one of our former research visitors, Professor Patricia Viata-Helgaert, who will lead the discussion today. Patricia is the Chair for Public Law, Public International Law and Human Rights at the University of Erlangen-Nuremberg and a member for the Center for Human Rights at that university. We're also delighted to welcome a newcomer to the discussion group, Julia Saavedra, who's a researcher in the Department of Cultures and Society at the University of Palermo, currently working on food sovereignty and sustainable development in Sicily, but formerly she was a Marie Sklodowska-Curie Fellow at the University of Strathclyde, a university with which the Bonavero does quite a bit of work. So a warm welcome to you, Julia. We're very grateful for you to make the time today. And just a reminder for those of you who've been before and those perhaps who haven't been before, the format for this discussion is that Patricia will speak for about 25 minutes on the topic of the rights to nature or the rights of nature. And Julia will then respond for 10 to 15 minutes, and then we will pick up your questions. So if you see the Q&A button at the foot of your screen, please do enter your questions as you're going along, and I'll moderate them to our speakers. The discussion group will end at 1:45 Greenwich Mean Time, so that's in about an hour and a quarter. Well, welcome, Patricia, and now over to you.
Thank you so much. I'm very happy to be back and to talk about rights of nature, very interesting topic. The demand to grant nature its own right is booming. Rights of nature can already be found in different legal systems. The Constitution of Ecuador is particularly far-reaching in this respect, granting a number of rights to nature or Pachamama, which can be claimed by any human person. This approach, like others from Colombia or India, refers to indigenous thinking. But we also see a growing interest in Europe to establish rights of nature without indigenous or religious references. In 2020, the Global Alliance for the Rights of Nature states, the Rights of Nature movement is taking the world by storm, and refers to a study that advocates introducing an EU Charter of the Fundamental Rights of Nature. This would constitute a nature-specific new legal instrument in EU law. The Inter-American Court of Human Rights took a different approach. The court integrated rights of nature into the Inter-American Human Rights Protection System. In a highly regarded advisory opinion from 2017 and in a judgment rendered in 2020, the court stated that the human right to a healthy environment includes an autonomous right. This addresses components of the environment, such as forests, rivers, and ocean, as legal interests in themselves, even in cases where a threat to human beings is not certain or proven. So this human right protects nature as such, as a human independent subject. According to the court, components of nature deserve their own protection, not only due to the benefits they offer to mankind, but also due to their importance for living organisms in general. We see that the court integrates human independent protection concerns of nature into a human right. This integrative approach leads to a first very simple observation. The family of subjects protected by international human rights law includes not only humans, but also components of nature. What type of human rights bearer can natural entities such as rivers or forests be? Are they of moral relevance as human beings are? And if so, does this lead to acknowledging that they hold moral human rights? Proponents of rights of nature do point to the intrinsic value of nature in order to recognize nature as a subject of independent rights. Referring to an intrinsic value is strongly reminiscent of a humanist conception of human rights. This conception understands human rights as those rights that human beings have simply by virtue of their humanity. In my presentation, I will deal with the justification of rights of nature in the framework of human rights and take traditional philosophical theories on human rights as a point of reference. These accounts are obviously built around human beings. This means that we will have to assume some kind of flexibility when we consider the possible grounds for rights of nature. Nevertheless, traditional human rights theories are, in my opinion, a very important point of reference. If we integrate subjects in the system of human rights protection, we must know if and how these subjects fit into this system and its underlying moral rationales. In the following, I will argue that nature's intrinsic value is not the adequate ground to consider nature as the bearer of moral human rights. Instead, the intrinsic value argument can, under certain conditions, establish a legal political justification for recognizing rights of nature as international legal human rights. I thereby follow a distinction offered by Alan Buchanan. He argues that we have to differentiate between the concept of human rights as general moral rights and the concept of international legal human rights. Buchanan relates international legal human rights to the founding of the modern human rights system at the end of the Second World War, when the distinctive idea was to create international law standards for how states have to treat those under their jurisdiction. So when we consider integrating rights of nature and the concept of international legal human rights, we consider legal, political, and jurisdictional reasons why the protection of nature should be made, and I quote, the business of the international community and be monitored by international human rights courts. In the first step, I will unfold the intrinsic value argument made by proponents of rights of nature. In a second step, I will examine this argument from the perspective of traditional human rights theories. These indicate that in order to attribute rights to a subject, we must be able to specify what constitutes its intrinsic value. In the third step, I will explore how environmental ethics specify the intrinsic value of the different subtypes of subjects that are assigned to the concept of nature. And in a concluding thought, I will reflect the potential of a legal political justification of rights of nature as an alternative. For proponents of rights of nature, referring to the intrinsic value of nature plays a crucial role. For them, it justifies that subjects of nature hold independent rights. In 1972, Christopher Stone was one of the first, I quote, seriously proposing that we give legal rights to forests, oceans, rivers, and the so-called natural objects in the environment, indeed to the natural environment as a whole. He embedded this claim in the broader context of conferring rights onto some new entity, as it was practiced, for example, with regards to women in the past. There's something, I quote, of a seamless web involved. There will be resistance to giving the thing rights until it can be seen and valued for itself. Yet it is hard to see it and value it for itself until we can bring ourselves to give it rights. We can see that according to Stone, granting rights to a subject and recognizing its own value are inseparably related. Another early proponent of rights of nature, Klaus Bosselmann, underlined the emancipatory effect of recognizing human independent rights. Bosselmann stated that a demand that has been made again and again, and is already part of the firm tradition of environmental law, is that of the upgrading of nature in the system of balancing environmental interests with economic interests of human beings. Since nature is not quantifiable, it is almost impossible to determine how much of it is still available or has been consumed. Only the permanent loss, for example, in irreparable forest damages, indicates that something must have gone wrong in the weighing process. Bosselmann came to the conclusion that the interests of nature and its parts can only be given greater weight in balancing processes if their intrinsic value is emphasized and legally justified. In line with this non-instrumental view, other authors, Susan Emmenegger and Axel Chencha, illustrate the consequences of such a transformation of attitudes towards nature. They say, to acknowledge an intrinsic value of nature means humankind is no longer the sole yardstick against which the utility of environmental protection must be measured. Rather, the new approach recognizes nature as a legal entity which is entitled to a certain amount of integrity independent of human interest. The demand to recognize human independent rights of nature because of its intrinsic value has remained an important leitmotif in the rights of nature debate. This is demonstrated by more recent comments on rights of nature. Now, in the face of an even more dramatic global environmental and climate crisis, proponents of rights of nature associate a radical paradigm shift with acknowledging nature's subjecthood. For them, it means including and recognizing the reality of planetary boundaries. It means adopting the balancing principle in dubio pro clima et natura. In this view, rights of nature help to fight the environmental and climate crisis, not only by reweighing interests in the balancing processes, but also by imposing stronger responsibilities on humans in order to modify their behavior. As David R. Boyd puts it, recognizing and respecting nature's rights will not put an end to all human activities, but would require eliminating or modifying those that inflict suffering on animals, threaten the survival of species, or undermine the ecological system upon which all life depends on. So nature is perceived not as a subordinated object, but as an integral ecological partner with its own right to exist and thrive. This brief overview on the rights of nature debate allows us to draw two important preliminary conclusions. The first is that the reference to nature's intrinsic value primarily has a defensive function. Proponents of rights of nature mainly describe nature's value by means of a demarcation from an anthropocentric, human-centered understanding of value. This helps to identify what nature's value is not, that is, serving human beings and their economic interests. Hence, nature's value is not to be equated with utility for present or future generations of humans, but it is beyond human interest. The rights of nature discourse focuses on determining the value of nature ex negativo. Pointing to this value has a function and purpose: to liberate natural subjects from human exploitation. But what is the positive definition of nature's intrinsic value? What are the properties, what are the features and the characteristics of the different components of nature that constitute this value and make them worthy of protection? We learn that natural subjects are intrinsically valuable, but we don't really know by virtue of what. We don't know if all subjects of nature are of equal value or not. But does this matter? Do we need to define nature's intrinsic value? I think this is a good moment to look at the position of human rights theories on this question. And I would like to do this on the basis of theories developed by James Griffin and Pablo Gilabert. Their accounts on the moral foundation of human rights differ fundamentally. For James Griffin, the concept of agency and autonomy form the necessary substantive account of human rights. For Gilabert, by contrast, human dignity as the expression of the inherent non-instrumental normative status of human persons serves as the moral foundation of human rights. Notwithstanding the fundamental differences in grounding human rights and human agency or dignity, we can abstract consensual underlying assumptions from Griffin's and Gilabert's account. Both accounts share the commonality that they first explain the existence of human rights from features, characteristics, or properties of human beings, which do not require external attribution or input. Second, both accounts build on the substantive clarification and specification of what these properties of the human being are like. They seem to follow the formula: in order to deduce moral human rights from human nature, we must be able to specify what attracts special protection in human nature. Put in other words, what human beings are like. Griffin draws attention to the difficulty of founding rights, not in virtue of any special status or relation to others, but simply in the fact that a person is a human being. And he admits that his conception of the human and the notion of human rights is not natural in the tradition of natural law theorists, but is a very specific and narrow concept. By singling out functioning human agents via notions such as autonomy and liberty, Griffin deliberately selects specific features, but he considers these features as especially important interests from which we can derive rights. Choosing agency as the relevant feature of the human being that ground moral human rights is, as Griffin admits, an expression of some form of stipulation. For him, the decision embodied in the stipulation is the decision to derive human rights from certain values constitutive of human nature. In line with Griffin, Gilbert negates that human rights depend on any kind of external recognition. Instead, human dignity as the moral heart of human rights points to the distinctive normative status of the human person. This status simply exists because it is inherent and the inherent status of human person. Like Griffin, Gilbert assumes that some degree of clarification of what constitutes the dignified human nature is inevitable. When confronted with a critical question if making human dignity a conditional status is really relevantly different from reliance on characteristics such as race or nationality, Gilbert makes important clarifications. In line with Griffin, he also tells us that the ethically tough question of what human persons are like has to be addressed. Without being able to specifically name the characteristics on which the human need for protection is based, no rights with the normative force of human rights can be derived. I quote, "For consider that we want to be able to answer questions like the following: why have people status dignity? Why does this status have the great normative power that it has? It is hard to answer these questions if we do not talk about what people are like and specifically illuminate what is so valuable in them that calls for decisive solidaristic support. We cannot just bang the table and say all human beings have dignity and human rights." End of the quotation. I think we draw important lessons from the consensus we find in Griffin's and Gilbert's approaches. In order to justify why a subject needs to be protected by moral human rights, one has to name and define the characteristics and features of the subject, which give rise to this level of protection. Without revealing what the subject is like, why it is particularly worthy of protection, there's no way to justify the specific normative force of moral human rights. Taking this approach of human rights philosophy as our point of reference, we find a crucial gap in the current debate on rights of nature. At the moment, it focuses on what nature's value is not, serving human beings. A positive determination of nature's value seems to be missing. So the question is, could this gap be filled? In order to answer this question, we have to examine in detail the specific types of subject that are assigned to the concept of nature. Following non-anthropocentric approaches in our environmental ethics, we can roughly differentiate between first, zoocentrism, that is the view that animals possess intrinsic value. Second, biocentrism, the view that all living organisms possess intrinsic value. And third, ecocentrism, that is the view that all forms of life, including organisms, ecological collectives, such as populations, species, and ecosystems, possess intrinsic value. One thing can be stated in advance: the more abstract the subject, the more difficult it is to identify characteristics of the subject that explain its intrinsic value. This holds true even when we assume what Patrick Bart calls a substantial plasticity of rights, such that rights can be based on properties other than conventional ones for justifying rights claims such as autonomy or agency or dignity. Promising candidates as rights bearers are animals, whose potential capacity to hold rights was originally conceived in the context of moral rights. Tom Regan introduced the concept of animals as experiencing subjects of life and linked this property with the demand to acknowledge animal rights. Recognizing the equal inherent value of animals means, for Regan, recognizing their equal right to be treated with respect. Sentience, that is encompassing the negative aspects such as pain, as well as the positive aspects, plays a central role in identifying the moral significance of animals. The feeling of pain, for example, is attributed to mammals, birds, fish, or reptiles. In addition to sentience, Peter Singer also argued that the capacity of some self-conscious animals to have preferences to life is of moral relevance. If we now apply the standard defined at the outset, according to which moral human rights are rights which exist as part of the inherent nature of a subject and depend on concrete characteristics of the subject, we have to state that conscious animals fulfill these criteria. However, our interest lies in the question whether the broader concept of nature holds moral human rights. When considering biocentric and ecocentric positions on the question of which characteristics constitute the moral status of the respective subjects of nature, we cannot find a clear answer. Biocentric positions, focusing on individual living things, differ over what properties of moral relevance characterize a living individual. One possible property is conation. That is the unconscious striving for growth and reproduction. Plants, like all biological organisms, possess this property. The concept of all living organisms is, however, broader, which makes conation a selective property that does not unite all living individuals. Claire Palmer revealed the range of possible subjects to illustrate this uncertainty. She says, could some kind of complex insect colonies, viruses, and bodily organs such as livers fall into the category of living things? Notwithstanding the ambiguity about morally relevant properties, most biocentric ethicists argue that, I quote, all living things can be benefited and harmed, and that therefore they have interests or a good of their own, and that this good is something we should respect. This is, however, not uncontested. Peter Singer, for example, stated, I don't think plants have interests in the morally relevant sense, any more than, say, a car guided through traffic by a computer would have an interest in reaching its destination. Neither plants nor the car are conscious. The challenge of identifying specific properties of the subject intensifies when it comes to ecocentrism. Ecocentrism deals with ecological collectives, such as, for example, a regional population of cougars, an endangered seabird species, a biotic community and its associated ecosystem, a landscape or a biome such as the rainforest. As in the case of biocentrism, the accounts as to why ecological communities or ecosystems should be accorded moral status differ considerably. Holmes Roulston, for example, focused on ecosystems as wild processes that create life. He emphasized the systemic value of the processes that produce individual organisms. Others refer to the uniqueness in composition and processes of ecosystems. A major challenge in determining properties of ecological collectives is that these are in constant flux as populations move through them and conditions change. Palmer, McShane, and Sandler come to the conclusion, the more indistinct, incoherent, and rapidly changing, arbitrarily defined ecosystems or communities seem to be, the more difficult certain kinds of ecocentric ethics become to maintain, especially those that depend on the idea of ecosystems having a good or interest that can be set back or damaged. What follows from this is the following. We cannot identify properties and derive interests. If we cannot identify properties and derive interests, nature as such cannot hold moral human rights. However, identifying these properties for each and every subcategory of natural entities we want to grant rights is, in my opinion, essential in order to derive rights and corresponding human obligations. The animal's capacity for suffering, for example, generates a clear moral obligation to spare animal suffering. We cannot draw such inferences about specific protection needs for ecosystems in general, given the state of the research considered here. To quote Robin Atfield, there are obvious differences between plants and other creatures that lack subjectivity, creatures that are probably sentient but probably lack awareness of their own future, such as fish and reptiles, and creatures that are in most cases probably self-conscious, dolphins, gorillas, and human beings. For a rights-based approach, different organisms have different moral significance, related to differences in capacities. The uncertainty about the different properties of natural entities may, however, only be a snapshot in time. This kind of definitional challenges might in future times be solved if rights of nature proponents adopt in detail findings of what is called natural ecosystem classification approaches. At stake for moral reasoning, the definitional uncertainty hinders to accept nature, including all possible subtypes, as bearer of moral human rights. I come to the conclusion. Finding that not all subjects of nature hold moral human rights according to traditional philosophical human rights accounts is, however, not the end of the debate. As demonstrated, rights of nature have already made their way into the judicial protection system of international legal human rights. There might be compelling reasons to protect subjects of nature in the framework of international legal human rights. The rights of nature discourse already draws attention to the serious deficits and protection gaps of a purely anthropocentric environmental and climate protection. In my opinion, it formulates thereby a strong legal political argument to strengthen human independent protection of nature and to make this the concern of the international community. If this legal political justification of rights of nature is supposed to succeed in the framework of human rights, I think one decisive element of the political argument will have to change. The value of nature as the central point of reference for the protection needs of nature cannot be defined as opposed to human interest. Moreover, the political argument in favor of human independent rights of nature will have to be justified against the alternative. My opinion, the alternative is to extend anthropocentric protection approaches. This could happen, for example, by broadening our understanding of protected humans. For example, by including future generations into the current protection system of human rights, or by understanding the human right to a healthy environment in a broader sense as rights of humanity, which would go hand in hand with a self-imposed limitation on human interventions in natural processes. This was my presentation. I thank you for your attention and I look forward to Juliet's comment and the Q&A part.
Thanks, Patricia. That was fascinating, very clearly stated. One of our attendees has asked whether you have a kind of written presentation that you could make available to attendees. And if you do, perhaps you could share it with Safisa. But if it's an article that's yet to arrive, what we can just promise our attendees is that we will tweet it once it is published.
Yes, this is the case. Exactly.
Okay, great. Well, thanks, Patricia. And Julia, now it's over to you to respond.
Well, thank you, Kate, and thank you, Patricia, for this wonderful presentation. I have to say that I've appreciated a lot, especially, well, now in hearing you, but also in reading your papers in general, how you really put everything on the table, so you don't try to hide things. If there is an argument that is tricky, you put it on the table. And this is not something that all scholars do. So I have to really start with this appreciation that's more general. Now, trying to go more into the details of what you've been talking about, I would like to first concentrate on the fact that you were dealing with two different types of normativity here. So on one side, there is the normativity of the classic or what you call traditional human rights theories, which is the normativity of ethical theories. So that tries to give final answers to things. This tries to find the final argument, the final justification, in this case for human rights, but it can also be for other types of topics. And this is a type of normativity that doesn't really have borders. You know, it's trying to give answers that are regardless of time, regardless of space, regardless of whom it's concerned. They are trying to give answers for now and forever. On the other side, you deal with the normativity that can be interpreted from looking at the legal system, so at judicial decisions, so our court decisions, our advisory opinion, or in general at the body of national or international law. In this specific case, you've been dealing with international human rights law, but of course, this can also be a type of normativity that is deduced by a national legal system. And this type of normativity is really restricted to trying to understand what is right or wrong, what is obligatory, forbidden, or permitted into a specific place at a specific time and for a specific amount of people. You've actually been dealing with the two, and I will try to explain a little bit more what I mean with this. Because you start by saying, you started by saying, it would be great if we found a moral justification for nature's human rights. So to justify the fact that nature has human rights. And in order to do so, let's try to look at what traditional human rights theorists give us. And when you've been looking at different theories, but specifically you concentrated on Griffin and Gilabert, and they both, as you said, reached to the conclusion that you need to find some specific characteristics in order to justify the existence of moral human rights. And of course, because you didn't, it wasn't enough for you, and I agree with it, to just say, okay, let's look at animals' rights, but you actually want to look at the rights of ecosystems, of endangered species. And you also wanted to make a difference and to be able to make a difference between endangered species, invasive species, or maybe you could also say the difference between, I don't know, a bacteria or other viruses, I mean, which are not considered by everyone human, living beings, etc. So because you wanted to really grasp all of this, you say it's impossible, or it's very complicated, it's very hard to find common characteristics that can justify moral human rights for these entities. And so you said, okay, well, our theories, our traditional theories that we looked at are not useful. You kind of put them aside. That's how I saw, at least that's how I interpreted your argumentation. You put them aside because they were not useful in order to, to reach our conclusion. And so in this move, you're actually doing two different things. So the first thing is that you're sort of somehow denying their normative force and only recognizing them an argumentative, a rhetorical force. So you are useful and I use you if you give me arguments to rhetorically say that, to be more rhetorically powerful, which is not how they are used to be addressed. So they are like, I'm telling you what the truth is. I'm telling you what morality is. And so it is quite, it's interesting the fact that you said, okay, you don't give me interesting answers, so I put you on the side. And therefore I move to a different types of normativity, which is the one that I can deduce by looking at the international legal system. And the other thing that this moves sort of shows is the fact that for you to do this, it means that somehow you already have a moral theory that is the one that you're starting from, and is the moral theory that we all have some sort of, a moral theory that is our vision of things, our way of looking at things. And it's like, it's there, and it's the one that allows you to say, okay, you as an ethical theory are not giving me the answers that I'm interested in. And of course, what were the principles you were moving from? Well, the recognition of the very important, the value of nature, regardless of as anthropocentric or non-anthropocentric. Nature is very valuable, it needs to be protected. So there was already some sort of pre-existing moral decision there, moral idea behind that. And in here, I would like to ask you, what would have you done had you actually found a good justification in these types of normativity? So, because there are some authors that do. There are authors that look at more traditional ethical theories or develop some and reach to the conclusion that nature in terms of ecosystems or endangered species should be recognized rights. And here I think of, for example, Thomas Berry and the Hearth jurisprudence, sorry, I never pronounce it the right way, Hearth jurisprudence theories that reach the conclusion that because natural law says that there are rights, that there are rights of nature, we are supposed to recognize rights to rivers, to birds, to mountains, different rights to different entities, but we are supposed to recognize them. And in a similar way, I mean, well, similar somehow, but Laura Westra in the ecological integrity group, they say in order to demonstrate that we are morally compelled to protect ecosystems, they say ecosystems are teleological beings, and therefore we should recognize that they have, a pursuit, a goal to reach, which is their own continuation, and therefore we are, bound to protect such ecosystems. So there are different ways, different authors that actually do find ways to justify the existence of, they don't call it moral human rights of nature, but they call it, it's a way of saying that they are moral rights of nature. And I really enjoyed the fact that you moved away from these theories, because I do find that they are quite problematic in different terms. So the first of all is the use of ecology that they do. So they use ecology, which is a descriptive science, to say this is how things should be. So in a very simple way, most of them fall for the naturalistic fallacy. I mean, they say, because ecosystems are in this way, then we have to protect them. This is Laura Westra, but I mean, also Barry does the same, or Leopold, although Leopold did the same. So the first of all is this is the first problem. Another one is that many of them do not really concentrate on who should tell us what is the correct interpretation of natural law, of morality, that we should take from ecology. So who is it? Who should be philosopher? Should it be a scientist? And it's not it's not a trivial point, because if then you deduce natural law, well, then natural law, it's quite of a burdensome thing, because it tells you how positive law should be. So this is something that you cannot really put under the carpet. And so I would like to hear what you think on this, because these are theories that could have been put on the table, but you decided not to. And I personally, I mean, I agree with you, but the reason why is because the type of normativity they use. Well, instead you decided to use a different type, which is the one that you can deduce from the international legal system, for example. And then I had another, and this is more really like a question on how you think we can interpret the decision, or the advisory opinion of the Inter-American Court on Human Rights, that said that the right to healthy environment is to be considered as having as protecting not just human interests but also natural interest. Because from this interpretation, in order to really make sense and to try to understand how this right would be constituted, I would think that the right to a healthy environment becomes a right with a double foundation. So the foundation of the right is not just the protection of the intrinsic value of humans and their interest, therefore, but also the protection of the intrinsic value of nature and therefore its interest. Now, if a right has a double foundation, then the two interests that are the grounding of that right somehow needs to be considered equal. They have to walk hand in hand. And that is perfectly fine if, well, up to the point in which we see a situation in which the promotion of the rights of nature or the interest of nature is in line with the interest of humans, or vice versa. So the protection of the right to freedom of expression helps the protection of of nature, because you can fight against, I don't know, a very environmental detrimental activity, for example. But what happens when the two clash? What happens if there is a case, for example, if in order to get rid of malaria in a certain area, you need to dry up a dump, and to dry up that dump will be potentially detrimental for biodiversity. So you have a clash between the right to healthy environment in human terms and the right to healthy environment in natural terms. So what do you do with this? What do you think the court would do? And do you think that at the end of the day, the court actually does hide a hierarchy at the end of the day that would come out only in cases of clashes? And I would probably think that the hierarchy would say that the human interests are above the nature ones. And if that is the case, then maybe this right to a healthy environment, the way it's construed, is not really with a double foundation, but just with a very large anthropocentric conception of human interests. They are so large that include, as you were saying, like future generations and humankind as a whole, but it's still a matter of human interest at the end of the day, and not maybe just not on paper, not on what they said in this opinion, but at the end of the day, it is still an anthropocentric vision. And here I stop myself, and thank you.
Thanks very much, Julia, for those really probing questions. And so I'm going to turn back to you, Patricia, just to have a few minutes to respond to Julia. And if I could just add one thought in, which is, you finish really saying that, well, that we're not going to be able to find a moral foundation or moral account of the rights of nature writ broad, and therefore what we need to do is develop a kind of legal political account. And I wondered if you had, I mean, you've said to us a couple of conditions for that legal political account, but you haven't given us any kind of framework for that. And I wondered if you have thoughts that you might like to share on what that legal political account would look like, and also whether it would be an account that would go right across all these very different kinds of beings, living beings, entities such as ecosystems, biomes, and so on, or whether in fact what one needs to be doing, even in a legal political account, is requires differentiation.
Thank you for all the very, very interesting remarks and questions from Julia and from you, Kate. I liked it very much the way you described my move. It's not helpful or useful. Let's move to another type of justification. I am convinced that it's not like a hierarchy. A moral foundation is in any way better, or the first approach we would look like, and the second best one is a legal political approach. I understand Buchanan and this approach in human rights theory that it is simply, first of all, the reality in human rights law that there are human rights we accept as human rights without being able to identify exact on what moral ground this right is to be granted or not. And in my personal opinion, I think it is right that there are international legal human rights which have a moral counterpart, but that we also have to protect some kind of paid vacation, or the right to go on maternity leave as a kind of personal freedom of decide how you want to live your life. So many rights which might have somewhere moral foundation, but which do not have a moral counterpart, exact one. So I don't understand Buchanan and this approach in human rights theory that we start with a moral one as the better version of founding rights, and then if we cannot make it, move to a second best solution, that is founding human rights and as political decision to make something the matter of the international community, which they are, as I said, after the Second World War. So this was not a move to look at the second best version of normativity, but in my opinion, they are two ways of grounding human rights. Why did I not look at ethical theories, for example, of earth jurisprudence theories? Because I was interested not in justifying rights of nature as such, but I was interested in the question whether they can be justified as a part of international human rights law. And that's a different approach. Because if we decide that rights of nature and other non-human subjects, such as corporations or maybe artificial intelligence, can be integrated in the system of international human rights, we have to deal with the justification approaches developed in the framework of human rights. That was the reason why I did look at this very specific way of justifying rights, because I'm not interested in the justification of rights of nature in general as an ethical justification, but I'm interested in the question whether they can be justified as part of human rights protection. And this double foundation you were mentioning, which also then leads to the question who speaks in favor of nature and who defines interest, is a very interesting one. As you said, I think the Inter-American Court does think of a double foundation, because the court says the right does have an individual component and this collective component, and the collective component is much broader and not like the European Court of Human Rights does, limited to the individual suffering, for example, to the resident living close to a polluted river who's sick. This is not the only subject we should look at when we think of the right to a healthy environment, but we have to broaden our understanding of what should be protected and for what reasons. As you said, I'm convinced if we go this step and if we say natural subjects are integrated in the systems, we have to accept some kind of equal level playing field. We cannot say, well, at the end of the day, there's a hierarchy with the human beings being at the top. But that leads to clashes, and this is clear. There will be clashes and balancing challenges like we face in everyday life of applying human rights, because human rights, if we have interferences in human rights, traditional human rights by states, the state is justifying interferences by reference to public interest. So we have a balancing situation in our daily life with the application of human rights, because there are always clashes of interest. And at the end of the day, there has to be the courts or the responsible authorities, commissions will have to take a weighing and balancing decision. So the problematic aspect is not, in my opinion, that will have to balance interests, but the question who then speaks at the end of the day authoritatively in the name of natural subjects, and what do we do if these opinions contradict each other? And here I think that is the main challenge for rights of nature, and all the proponents of rights of nature who take this approach away from indigenous protection or religious connections, because there we might have a group of people responsible or who feel connected to the natural entity and have some kind of authority to speak in the name of the river if there's a religious or indigenous connection. But taking this concept away from these roots makes the question of who speaks in favor of the subject, of the natural subject, a big challenge. And I have so far not seen a solution to this problem. Now to Kate's question, how would the legal political account look like? I think, frankly speaking, we will face exactly the same challenge, that is defining the properties of the subcategories. And this is all the text and all the positions I could read so far did not give me a clear answer how we deal with that. What is the right of the Amazon rainforest in detail? Because if we want to include this approach into human rights practice or legal practice, we will need to know what the content of the right is. It's not enough just to, the quotation I gave you, to bang on the table and say, the river has rights. We must know what kind of right and in detail. And the right to thrive, for example, which is mentioned in this context, is not really determined. It does not really help us to draw concrete conclusions. So I did not mention it, but this, what I call the definitional challenge, is more or less the same if we accept that there are strong political reasons to accept rights of nature in the framework of human rights.
Well, thank you very much for that response. And you'll see